Hi, I'm attorney Renee Osipov with Chelle Law, and we assist dentists with employment contract issues. The issue that I'm addressing today is if a dentist can solicit their patients after their contract has ended. This answer will directly rely on their employment agreement that they had previously signed with their employer. In most employment agreements, there's going to be something called a non-solicitation clause. It's typically under the restrictive covenants. It's similar to a non-compete clause. A non-solicitation clause is normally listed for a period of time for 1 to 2 years. It's enforceable. I don't know if I've ever seen one over 2 years. And within that restricted period, you may not solicit patients. Also listed in there could be employees, independent contractors, or third-party vendors. And the reason behind this is that the employer has spent a considerable amount of time and money recruiting, licensing, building relationships with patients, employees, other sort of work relationships. And so they're wanting to protect that. And that's why there's the non-solicitation clause. But let's go further and discuss what does solicit mean? So to me, it means reaching out, enticing, encouraging, asking patients or employees to come with you whenever you're leaving. You might be starting a new practice, or you might be going to just a new employment opportunity. And so you cannot reach out and directly ask or encourage the patients to come with you. But what is not included in the solicitation clause is if a patient reaches out to you. So most health law addresses patient choice. So patients cannot be restricted from choosing who they want their healthcare providers to be. So if a patient reaches directly out to you or asks where you're going, you absolutely can tell them your former employer cannot stop that patient from seeking you out. They just simply can't do that. You also want to be careful in that non-solicitation clause about employees. So if you leave, some non-solicitation clauses actually even go further and say you cannot solicit or even hire employees during that restricted period. So if you're operating your own practice, that means you absolutely cannot hire anybody from that practice within that period of time. Or contract with third-party vendors, maybe for marketing services. It's just kind of specific to your field, but any type of contractual relationship. So you definitely want to refer back to your agreement to make sure that you are clear on what you can and can't do. Typically, general advertising is not considered solicitation. If you're advertising for the masses, it's a billboard or social media, something like that. That's not normally a violation of your non-solicitation clause. However, if you are advertising and pinpointing specific patients that you had previously had with your employer, then you would likely be in danger of violating your non-solicitation clause. And that can be, direct letters to those patients specifically, kind of things similar to that. If you'd like more information on non-solicitation clauses and employment agreement issues in general, you can check out our website. It's Chelle Law, CHELLE law.com. Our number is also listed below in the description. We're happy to set up a consultation with you. We can go over your employment contract and see what you can and can't do, and even specifically within a solicitation, if you can or can't solicit your former patients, or for how long. So so that's about it. Like I said, reach out if you have any other questions. We're happy to help. Thanks.